Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business. Lee Kaplan, he's an attorney, does a phenomenal job keeping people informed about really some, not only legal cases, but how law relates to society in general. Some really interesting commentary. I always enjoy having him on the program. His firm is Spicer, Kaplan, and Veselka. That's skv.com. Tell us a little bit about your firm, and let's get into our topic today.
Well, our firm has just over 20 lawyers, and we do all sorts of civil, commercial cases, plus white-collar criminal matters. And that includes both trials and arbitrations and appeals. The most recent thing at our firm is that 3 of my partners secured the acquittal of a lower-level BP employee who was basically the last guy charged in the Deepwater Horizon matter. And this is Robert Kaluza. He was acquitted over in New Orleans by a federal jury after a 2-week trial. So we handle the gamut. That's a case in which our people had to review something like 8 million documents to expose the government's case for what it was. So we've got a wide-ranging practice.
So how many charges did he initially have?
Well, they started with 23 charges, 22 felony charges. That's 2 for each of the 11 deaths for negligent manslaughter and grossly negligent manslaughter. The district court dismissed the negligent manslaughter cases because the government charged under the wrong statute. That was upheld on appeal. The government ultimately realized it would never be able to convict this man for gross negligence, and not too long before the trial, they dropped those claims. That left a Clean Water Act count for which he could have received up to, 11 months and 29 days, just shy of a year. And to Mr. Kaluza's credit, he said, look, you've turned my life upside down. I want my day in court. And that takes a lot of guts. But he did, and the case was tried, and he was acquitted in less than an hour. So it was pretty clear he was not at fault. This is something he didn't cause, and there were a lot of things that combined to cause this terrible tragedy, but Bob Kaluza was not one of them.
Wow, well, that's awesome that it worked out that way, and it's great to have a firm like you in his corner. Talk a little bit about, something that I hear a lot about. I hear it as a kind of a nuisance to some, but, almost a savior to others, which is arbitration clauses in contracts. First of all, kind of give us some background on what they are.
Well, there are opportunities when people have business disputes of filing a lawsuit and going through the regular procedure of a lawsuit, or either by some contract agreement, or maybe subsequently people sometimes agree to arbitrate those. Arbitration, as opposed to mediation, is a binding ruling. And there are entities out there that will supervise arbitrations, and sometimes parties just may more or less do it on their own. It's probably easiest if you want to have an arbitration to have a clause in your contract. There's a real dispute out there, for example, whether consumer contracts can all be subject to arbitration and employee contracts, but between businesses, generally, arbitration is enforceable. And there's a Federal Arbitration Act, and the states encourage arbitration, too. They'd rather have their courts less clogged.
Right.
So there's some basic clauses that you would want to put in an arbitration clause in a contract. And I would encourage anybody to get a lawyer to look at this. You can download sample forms from groups like the American Arbitration Association, but there are key issues you need to decide. What law would apply if you have an arbitration? Where is an arbitration to be held? And that can be important because if you have 2 Texas companies, clearly they're not going to want to arbitrate in Nebraska or New York or, God forbid, London. But sometimes if you're a Texas company and you're dealing with somebody from New York, they'll try to put an arbitration clause in there that requires the arbitration to take place in New York. That would naturally be much more expensive for you as a Texas business person. So
not only because And not only because the cost of going there is going to be more, but the cost even of the legal process is probably going to be higher as well. Not to mention having to have to hire probably a totally different attorney. I mean, it really begins to add up.
That's right. And then there's the issue of who are going to be your arbitrators. You can have a panel, or you can have a single arbitrator. Most people go for panels. Now, that can increase the expense. And usually what happens is each side appoints a panel member, and the two of them get together and pick a chair, or if they just can't do it, there are rules by which that's done. And sometimes people will agree in advance that their arbitration clause will say a single arbitrator on whom the parties will agree, or if the parties cannot agree within, say, 30 days or 60 days, it'll be administered under the rules of, for example, the American Arbitration Association. And normally that'll be 3 people. So there's an incentive for the parties to agree on a single arbitrator. And hopefully if the parties are in proximity, they'll find an arbitrator who's in the neighborhood or in the same state who they both respect. And usually their lawyers, both sides' lawyers, can find somebody, a former judge, a senior lawyer, somebody who's skilled in the industry, if it's, say, a construction dispute, to be the sole arbitrator to take the evidence and render a decision.
Talking to Lee Kaplan, Spicer Kaplan of the Vaselko Law Firm, skv.com. And so will there often be in the arbitration clause specific language as to whether or not it'll be a panel, or is that kind of thing usually sorted when things become tense?
Well, either A, the clause will specify that sort of thing, or it'll just say, according to the rules of, most typically in the United States, the American Arbitration Association. Now, if you're dealing with a foreign company, there are many organizations. There's the London Court of International Arbitration, for example. But usually, people more often just say, according to certain rules, subject to, and they'll set out specific issues, such as it'll be, any disputes will be resolved under the laws of, say, the state of Texas. And the seat or the venue for the arbitration will be in, typically people here will say, Harris County, Texas, if that's what you want. Sometimes you'll agree to another venue, but naturally a business here would prefer to be here because it's usually more convenient. And to the extent they have regular counsel, their regular counsel are usually in the same community.
But let me ask you, we only have a couple of minutes left, about the language of the clause. I know, for example, if you have a non-compete, if it's worded in such a, in certain ways, it almost becomes, useless because of it's so crippling in the ability of an employee to be able to get a job afterward. How important is the specificity of the language for something like this?
Well, the laws about covenants not to compete and how long they can be and how restrictive are somewhat separate from the rules of arbitration, but and how extensive they can be. But if you're just looking for an arbitration clause, a good starting point is to simply go on the internet and look up sample arbitration clauses, and then you'll see some that offer you options on some of these issues. Now, the issue of a non-compete is separate, how restrictive it can be, both as to territory and area of practice or work and duration. I think generally 1-year non-competes in an area where somebody has practiced in that particular, area of endeavor and limited to, say, a region in which they have called on customers or used their expertise, generally are enforced. Those that are longer than a year are always more questionable. Those that attempt to extend the geographic territory beyond the area where somebody worked for you are always going to get greater scrutiny. And those that try to extend beyond the area of endeavor in which you practiced. I mean, if you're some sort of technology expert on particular kinds of metals, it's going to be very difficult for a business to enforce a non-compete where you can't call on anybody for some other product that your company sells that you were not selling.
Yeah.
So those need to be limited as to time, scope, and geographic area.
Lee, I got to wrap it up on that point. Lee Kaplan, Spicer, Kaplan, and Veselka. That's skv.com online. Thanks so much, sir.
Sure. Thank you.
Great job as usual, and when we come back, more for you. Do want to remind you, best content here is found over there at usdailyreview.com.